Let's go through the remaining examples from the worksheet that was attached in Moodle. And I'm looking at the risk. It says risk of loss issues. It's under example 2. I guess I should have called it example 3, but I misnumbered. It starts with Macy's department store. So that's the one we're going to start with. Macy's department store, located in Capital City, contracts to buy 6 gross of sweaters from Knits Incorporated, which is located in Boston. The price is agreed to as $1,200 gross, FOB, Boston. Knits delivers cartons containing 850 sweaters to Tony's Trucking Service and arranges a contract for their delivery to Maisie. Knits receives a bill of lading from Tony's Trucking, which it immediately mails off to Maisie along with other details of the shipment. While en route, Tony's truck is caught in a flood. Many of the sweaters become waterlogged and their colors run. They arrive at Macy's, but she declines to accept any of them. And the question is, who bears the risk of loss? And I do want to note that a gross of sweaters that would contain 864 sweaters, in case you did not know that. I didn't put it in there. So when you answer the question, who bears the risk of loss? And in this case, the risk of loss at the time of water damage was on Knits. Since this was an FOB place of shipment contract, the risk of losses occurring in transit would normally be on the buyer. But however, Macy can point out that the seller is bound to a shipment contract. Here, a seller who's bound to a shipment contract and they do not fulfill their obligations because the goods put in the hands of the carrier fail to conform to what is called for under the contract, i.e. here was tendered, the tendered failed to conform with the contract, called for the 6 gross or 864 sweaters. Knits shipped only 850. So for the buyer, Maisie, here, to avoid the risk of loss, there need not simply be nonconformity in tender, but a nonconformity such as to give a right of rejection. Maisie could have rejected even a perfectly undamaged delivery in this case of the 185 units, bearing any other information we have. The risk remained on the seller until Knits had an opportunity to cure, or whether or not Macy's accept. And cure is not really relevant here because the goods were damaged. But the key point here is that Knits shipment didn't conform with the goods of having to ship the entire thing in one shipping delivery. There was no installment contract here. So it shipped non-conforming goods, which would have been the 864 sweaters. So Knits continued to bear the risk of loss. So in this instance, it's on Knits. So suppose instead that Knits has delivered a full 6 gross of sweaters, that's 864, to Tony's, but had failed to notify Macy's of the shipment. The first she knows of it is when the sweaters arrive in their sorry state at her store, and she declines to accept any of them. Who bears the risk of loss in this case? This is a little bit trickier. We went through the rules regarding tender of delivery, and one of the requirements is that notification, providing the bill of lading and notification of shipment, and Knits failed to do that here. So Maisie could argue that's a ground for rejection. But the question then becomes, does the seller's failure to give notice to some degree contribute to the delay or the damage in this case? Do you think if they arrived in perfect condition that Macy could reject them? So then Knits' failure to give notice in this instance would not in and of itself have been a ground for a rejection? She's rejecting them because they came in a sorry state, and she's saying she doesn't have the risk because she failed giving notice. This is a tricky one. Under the unfortunate circumstances, the failure to give the notice is probably going to leave the risk on Knits. There is one case that actually stands for that. I don't know if a court would, having these circumstances, may consider that the notice didn't cause the damage or the failure to give notice, so it wouldn't really technically be fair to knits. But in this instance, and with the rules of the obligations that we discussed of the seller, prompt notification with the relevant documentation, he didn't do that here, so more than likely NITS is going to have the risk of loss yet again. Suppose that NITS had delivered 864 sweaters to Tony's Trucking and had in addition given proper notice to Maisie. Tony drives through rough country and stormy weather, but there is no major flood and his truck is never swamped with water. When the sweaters arrive, Maisie examines them and finds that the colors have run on a good number of them. Tony insists that his truck had stayed watertight throughout the trip and that the sweaters must have been like that to begin with. Maisie telephones NITS and complains that they included in the shipment a number of defective items. She intends to reject the whole shipment. The delivery manager for NITS responds that its records indicate that his firm shipped 6 gross of sweaters, all of which met the contract specifications. He suggests that they must have gotten wet during shipment, whatever Tony may say. Assuming there is significant water damage to some of the sweaters, who bears the risk of loss? Another tough one, and the answer is we really do not know who bears the risk of loss under this situation. This question is designed to drive home the point that when a shipment arrives in poor shape, it's often difficult to, if sometimes impossible, to tell exactly what happens. And when and where the damage is, or more is probably of interest, but we really don't know what happened in this case and whose fault it is. If the sweaters were in poor condition before they left NITS plant, then obviously Maisie needs not accept them and obviously bears no responsibility for the damage and can refuse to pay for them. She may even have a claim for some substantial damages because of NITS' failure to perform on its contract. But if, on the other hand, the sweaters were in good order when they left the plant but were damaged while in transit, then Maisie bears the risk of the loss for this occurrence and must pay for them under the contract because NITS gave proper notice, and all he had to do is put them in the hands of the carrier per the shipment contract. And of course, the issue here isn't just who has to bother of going against poor Tony, because Tony has an argument that the sweaters were in bad shape to begin with. He may not have to pay anything, but really it's all going to depend on what happened and when. And that's sometimes going to be left to, that's not in the code for determination. It would be up to the courts to decide. And really the bottom line is the insurance. Everyone probably in this case had some sort of insurance in place. So the insurance companies will duke out who has to pay for what. We'll talk about Macy's and NITS again. There always seems to be contracts with these folks. I think I'll use them all semester long. Performance. Macy's department store located in Capital City contracts to buy 6 gross of sweaters from Knit Corporation. The contract provides that Knits will ship the sweaters from its manufacturing plant in Boston to Macy's. Knits arranges for the sweaters to be picked up by Tony's trucking service. Tony picks up the cartons and agrees to deliver them to Macy's, giving Knits a bill of lading covering the sweaters. Knits sends this bill of lading to Maisie along with a notation that she should expect to hear from Tony when the goods have arrived in Capital City so that she can arrange for delivery to her store. At this point, has Knits fully performed its tender obligations? And the answer would be yes. We made a contract with Tony's Trucking. That was reasonable with regard to the natures of the goods, which are the sweaters under the circumstances. It's a shipment contract. So all he has to do is put them in the hands of Tony and then provide Macy with the appropriate documentation and notice. So here there is tender on the part of Knits. The next part of this is, would it affect your answer if you were to learn that the sweaters never arrived in Capital City and are never delivered to Macy's? Your answer should be no. There has been an effective tender, so the risk of loss is shipped to Macy's. So even if the sweaters are somehow lost in transit, that's no sweat off Knits' back. They've performed according to the contract, and they did their proper tender obligations. Would your answer to the previous question change if Knits had turned over only 5 gross of sweaters to Tony's Trucking. We just did a similar example. In the other one, Knits cannot have effectively tendered if it had not put conforming goods in the hands of the carrier. So in this instance, they had not. So if anything happens to the sweaters, that is going to be Knits' risk. In number 3, what if Knits had shipped the full 6 gross of sweaters but had simply placed a bill of lading in its file and never told Macy's the shipment was coming? Do we have tender obligations? Again, we kind of discussed it under the risk of loss. But here, Knits does not tender because it failed to meet the obligations. And we talked about having notice in the damage of goods, and the lack of getting notice didn't really result or lead to that damage, so it seems slightly unfair. The reason we have notice, so the buyer has the right to inspect. The buyer has the right to inspect and get these these tender obligations set forth by the seller. The buyer has to know the goods are on their way, right? They have to know what mode of shipment. Otherwise, how could a buyer know when and where to expect the goods and have the ability to get them delivered properly to their location from the carrier? So it's important for them to get notice so they can actually get the product or the goods. The other instance, even though it'll probably turn out that Knits would be responsible for the failure to give notice. The goods arrived and it wasn't a notice issue, but they were just damaged along the way. This example, the reason for the notice is so that a buyer can take delivery on their goods. And the last example involving the revocation of acceptance, Bill versus the trailer company, Trailer-O-Rama. This involves the ability to be able to, after accepting goods and then later finding out they do not conform, and then you want to revoke your acceptance. Remember the rules regarding that. So Bill buys a mobile home from Trailer-O-Rama in Springfield. The unit, which the contract calls to be equipped with built-in heating and air conditioning, is delivered to Bill's land and set in place in November. During the winter months, the heating unit works with no problems. In May, when the temperature first goes above 80 degrees, Bill turns on the air conditioning. Air blows out, but it's not cold and it's not even cool. Bill immediately calls a mechanic to check the air conditioner. It turns out that there is no cooling system at all. Behind the air conditioning panel, there is just a hollow space. Can Bill revoke his acceptance of the trailer? It seems like revocation would be good here. The only issue is whether the attempted revocation took place within a reasonable time after the buyer discovers or should have discovered the grounds for it. It's about half a year has elapsed. But still, under the circumstances, I would say that Bill can revoke his acceptance. The trailer company might argue that Bill should have discovered this defect earlier and maybe be able to go after for damages for not having it on there versus the whole I'm not accepting this trailer. But under those facts, Bill would be able to revoke his acceptance. How about the next one? Suppose that instead of immediately calling in a mechanic in May, Bill does nothing. By the next day, it's cold outside again. When a heat wave strikes in June, he once again turns on the air conditioner. Again, it blows only tepid air. Now he checks out the unit and for the first time discovers a lack of a cooling system. Could Bill revoke under this set of facts? Is this any different? What may eventually have made a difference? How about this reasonable time? Is that reasonable time? Bill probably lost his right to revoke because of the delay in making the revocation. In May, the temperature first goes up, he turns on the air conditioning, nothing's blowing out. He shuts it off. Doesn't do anything. The buyer would have to take some reasonable steps. So Look at the reasonable time component. Reasonable time requirement must include the time beyond which a seller is attempting to adjust or cure the problem. In this instance, Bill discovered the defect in May, he did nothing. That's going to be the crux of why he's probably not going to be able to revoke his acceptance. Now, that does not mean he's not entitled to anything there, because the contract called for him to have a unit. He just can't reject the acceptance of the trailer. He can't give the trailer back. He might be able to have them come in and put a new system in, or be reimbursed for the lack of having it on there. He does have recourse. He just can't revoke his acceptance.